All rise.
Further hearing in the appeals, please on the application against the Governing Body of JFS and the United Synagogue.
The last point.
At the end of the proceedings yesterday afternoon, I was submitting that if the test adopted by the Court of Appeal were correct as a matter of law, then it would restrict the ability to provide religious services to those people who are recognised by synagogues, whether they're Orthodox or whether they're non-Orthodox, to be Jewish. And I gave an example of evening classes in religious instruction. My Lord Brown asked me, well, why should the teacher want to exclude persons who are not Jewish? It may be for practical reasons. It may be that the teacher, for example, is offering one-to-one services. There may be a limited amount of time. There may be more people who want these services than he or she is able to assist. But the point may arise also in relation to services which relate to fundamental religious obligations. Can I give the court the example which is addressed? I don't invite the court to turn it up, but it's addressed in the United Synagogue's printed case at paragraph 32c. And the example is the Moel. And the Moel is the person who performs the religious practice of ritual circumcision of the newborn son on the 8th day of his life. Now suppose, as is the case, the Moel performs this function under the auspices of the United Synagogue, or it doesn't matter, the Reformed Synagogue, the Masorti Synagogue, or the Liberal Synagogue. Now, if the Court of Appeal's judgment is correct, it follows that the Moel cannot confine the service that he provides to members of the public to those who are Jewish, as recognised by the United Synagogue, the Reformed Synagogue, or the Masorti, or whoever. He would also be obliged by the Race Relations Act to offer this service to others who wish their son to be circumcised. And of course, as a matter of practical reality, there are people other than Orthodox Jews who wish their sons to be circumcised, maybe because they are adherents of another religion or for health reasons. And I do submit that when one's talking, as one is, about a fundamental religious obligation, it would be a surprising conclusion were the Moel acting under the auspices of the United Synagogue or another synagogue obliged to apply some form of religious practice test to say, I will confine my services to those who practice Judaism, when of course the fundamental religious obligation to have your son circumcised is not dependent at all on religious practice. It's an obligation that is followed by many persons who are Jewish who have no religious practice at all. And I say that Parliament has carefully considered, and rightly so, the difficulties that are posed by religious discrimination of precisely this sort, and Parliament has made specific provision, as I showed the court in section 57.3 of the Equality Act, and the Court of Appeal's approach that this is discrimination contrary to the Race Relations Act would frustrate the intentions of Parliament. Now, there's one final point I want briefly to mention, which I hope is a supplement to the point I've just been making, and it is this, that I say that human rights law also suggests that the court should be very slow indeed, with great respect, to intervene in relation to what is essentially a question of how best to define a Jew, either for the purposes of a faith school or indeed in any other context where religion is the vital element. And I rely for this purpose on Article 9 of the Convention, which protects, as the court knows, freedom of thought, conscience and religion. But the reason I rely on Article 9 is not because I am focusing on the particular beliefs of individual adherents to the religion. I am drawing attention to Article 9 because the case law of the Strasbourg Court emphasises the vital need for the autonomy of the religious authorities. And there's one authority, one case that I wish to draw attention to, which is the Hassan case, which the court will find at volume 3 of the authorities at tab 25. This is the same case as Lord Hope and Lord Brown and the President and Baroness Hale will recall from the Purger case last term that dealt with the need to regulate the discretion of administrative authorities. It's that case, volume 3, tab 25. The court will see the context from the headnote. The first applicant had been elected the chief mufti of Bulgarian Muslims, and he'd replaced the previous chief mufti. And the state enacted a decree and a decision which proclaimed changes in the leadership and the statute of the Muslim religious community, whereby G was favoured over the first applicant. So, in essence, the state was interfering in relation to who should be the leader of the Bulgarian Muslim community. And strong facts that it's the principle that I rely upon. The principle can be seen, my lords, my lady, at page 1358 of the judgment. Paragraph 62, where the court, and it's the Grand Chamber tells us in paragraph 62 that it recalls that religious communities traditionally and universally exist in the form of organised structures. They abide by rules which are often seen by followers as being of a divine origin. Religious ceremonies have their meaning and sacred value for the believers if they've been conducted by ministers empowered for that purpose in compliance with these rules. The personality of the religious ministers is undoubtedly of importance to every member of the community. Participation in the life of the community is thus a manifestation of one religion protected by Article 9. Where the organisation of the religious community is at issue, Article 9 must be interpreted in the light of Article 11, that's freedom of association, which safeguards associative life against unjustified state interference. Seen in this perspective, the believer's right to freedom of religion encompasses the expectation that the community will be allowed to function peacefully, free from arbitrary state intervention. The autonomous existence of religious communities is indispensable for pluralism in a democratic society and is thus an issue at the very heart of the protection which Article 9 affords. It directly concerns not only the organisation of the community as such, but also the effective enjoyment of the right to freedom of religion by all its active members. Were the organisational life of the community not protected by Article 9, all other aspects of the individual's freedom of religion would become vulnerable. And we respectfully commend that statement of principle to this court as vital in understanding, we say, the issues that arise in the present case. Now, it is true, and I readily concede, that of course the religious community has no immunity. There is no principle that the state is precluded from interfering with the rules that the religious community adopts for itself.
Well, the Percy case I mentioned yesterday is quite a good example of that, because it's a very strictly understood rule in Scotland that the Church of Scotland has its own autonomy in religious matters, but where it entered into a contract, it was open to the scrutiny to see whether there was a sex discrimination, and that divide is quite clearly identified in that case.
I readily concede that, because, not least because Article 9 is not an absolute right.
No, but it does show where the case really pinches in your situation, where you are moving into, as it were, the public sector,
yes,
through the system, which you've explained to us very carefully.
Yes.
And therefore it is open to scrutiny.
I entirely accept that, and I entirely accept also that if the court were to find that these are matters properly analysed of race discrimination, then we can claim no immunity. My point, however, is that when the court is deciding, as it must, what is the true analysis, whether our analysis is correct or that on behalf of E is correct, an important dimension that should be taken into account by the court is the recognition of the vital need to maintain the associational autonomy of the religion. And I do say that is a vital element in this context. It's also a vital element because the approach adopted by the Court of Appeal is going to deny the Jewish community opportunities that are enjoyed by other religious groups. And therefore one is in the field of Article 9 read with Article 14. And the court, in my submission, needs to be very clear indeed that this is truly not divisions, policies that are adopted on religious grounds as opposed to racial grounds. That's how far the point travels. There's one other authority that is of assistance here in indicating the test that should be applied before intervention, court intervention or state intervention is appropriate in relation to religious autonomy. And that's the Church of Scientology case, which is at volume 2, at tab 17. Volume 2, tab 17, a complaint by the Church of Scientology of Moscow, a complaint which succeeded on its merits against the Russian Federation, that there had been a breach of Article 11, read with Article 9, by reason of the state action to strip the Church of Scientology of its legal status. Again, I refer to the general principle, which the court will find at page 320, at paragraph 71, where the court tells us that it refers to its settled case law to the effect that, as enshrined in Article 9, freedom of thought, conscience and religion is one of the foundations of a democratic society. It is, in its religious dimension, one of the most vital elements that go to make up the identity of believers and their conception of life. But it's also a precious asset for atheists, agnostics, skeptics, and the unconcerned. I draw that to the attention of Mr. Wolfe, who's going to make submissions on behalf of the British Humanist Association. The pluralism indissociable from a democratic society which has been dearly won over the centuries depends on it. And then at paragraph 75 on the next page, we see the test. At paragraph 75, the state's power to protect its institutions and citizens from associations that might jeopardize them must be used sparingly, as exceptions to the rule of freedom of association are to be construed strictly, and only convincing and compelling reasons can justify restrictions on that freedom. Any interference must correspond to a pressing social need, and the court emphasises that in the context of Article 9. And my case on this point is not that human rights law confers on us some absolute immunity in the context of education, far from it. My point, as I say, is that when this court is asking itself whether the policy is in truth a policy that distinguishes between persons on the grounds of ethnic origins, or in truth distinguishes between persons on grounds of religion, and when the court recollects that the real dispute, as I put it, between E and the JFS is in identifying who is a Jew for the purposes of the oversubscription policy and how you properly give priority to Jewish, in inverted commas, children, a very large degree of autonomy and discretion is appropriate, in my submission, for the religious authorities. That's how I put the human rights point. My lords, my lady, I'm very grateful for the court's patience. Those are the submissions I wanted to advance on behalf of JFS, unless there are other matters that I can seek to deal with.
I've just got one question. Would it be unlawful for a religion to say this religion is only open to a particular race?
No, Lord, because that would be the clearest adoption of a criterion which distinguished between persons by reference to their race.
That would be unlawful.
That would be unlawful,
yes.
Certainly. The mere fact, it's no part of my case to suggest to the court that the mere fact that one is in the context of a religious body provides an immunity from the application of the criteria in the Race Relations Act. And examples were given of this in the Court of Appeal, examples of the Dutch Reform Church, which we were assuming for the purposes of argument. I've no doubt, I've no knowledge of whether this is accurate or not, but assume one has a church that adopts a policy that only white people are eligible for membership. And that policy is adopted for religious reasons. That is what they genuinely believe is the commandment that comes down from the Almighty. Now, there are a number of answers to the point. First of all, that would be to adopt a criterion that is expressly based on a racial factor. All white people are on one side, all people who are not white are on the other side. And there is no difficulty in my submission in seeing that that is to adopt a criterion that offends against the Race Relations Act. There are other answers, of course. A faith school could not possibly adopt such a criterion because it is inconceivable that the Secretary of State is going to recognise under Section 69(3) of the 1998 Act a school which adopts such an approach. Nor would an oversubscription policy of that sort be consistent with its code of practice. Nor, of course, is it conceivable that any human rights Article 9 point could possibly assist such a church, given that it is well established under the jurisprudence of the Convention, partly by reference to Article 17, that doctrines of that sort are fundamentally inconsistent with basic notions of decency and humanity. So for all those reasons, I don't accept that example.
But, I'm sorry, can I just follow that up, Lord Planning, because I'm shamefully ignorant of how it all started. But originally, some tribe gets together and says, right, this is our religion, we are Jewish. I mean, if they had simply said, right, only people descended from our tribe are going to be recognized as members of the Jewish religion, and they hadn't made any provision for conversion into the faith, I mean, would that then be fatal several millennia on to their being regarded as that being an acceptable touchstone of religion?
Because the people nowadays are the descendants of those who were...
By definition.
Well, but by definition, I say no for the reasons I gave. This is not a test that is based on ethnic origins, for the reasons I gave to the court, that one has here a position of the people who qualify being of all sorts of ethnic origin, not least because of conversions that have taken place.
No, I'm saying, but postulate that originally they hadn't made provision for conversion into the faith. Assume that there it was, it's our tribe and its descendants who are to be recognized as members of the religion.
Yes.
No, you can't convert in. Now assume that.
Well, I would still submit that that would not be a test of ethnic origins, because the people who would qualify nowadays and the people who would not qualify nowadays would be of all sorts of ethnic origins. Some of them would be people who are associated with Judaism and are seen to be associated with Judaism. Some would not. There would be a whole range of people who...
I'm sorry, I don't understand that. I postulated that there wouldn't be a whole range, that by definition...
No, but there would nowadays.
Well, that's because of conversion.
No, it's because nowadays some of the people who would be eligible under the oversubscription criteria would be people who have no connection whatsoever with Judaism, other than that their great to the nth degree grandparent was Jewish. But their ethnic origins, as they are perceived today, and as they are today, would or would not be Jewish. They would have no links. Ethnic origins under the Mandler and Lee test depends, as we saw yesterday, on a whole range of factors. And there would be many people who would fall within the category of eligibility who simply could not be said under the Mandler and Lee test to be of Jewish ethnic origins.
It would be a different matter if the tribe had said you can only marry people of our own tribe.
Yes.
I mean, one of the things that's quite distinct about this is it's the maternal line that matters.
Precisely
and
so.
Over the centuries, of course, there could be a tremendous mix of races that come into families through the fathers.
Yeah. Well, I'm grateful. I mean, exactly so. But I say to Lord Brown that the historical link tells you nothing about the ethnicity of the person today. The person today who is eligible because of a religious test which is not coexistent with the person today's actual ethnicity in Mandler and Lee terms. The person today may be of Jewish ethnic origins, or he or she may not be of Jewish ethnic origins under the Mandler and Lee test. And that simply does not determine whether they are eligible under the oversubscription criteria. They may be someone like M, who plainly is of Jewish ethnic origins for the purpose of Mandler and Lee, but he's still not eligible. They may be someone who has no Jewish ethnic origins for the purpose of Mandler and Lee. He has no link with Judaism today, but he's still eligible to go to JFS because of a religious test. That's the point we're seeking to make.
May it not be said that those Orthodox Jews who identify Jewishness by reference to the criteria which we know about, are in fact simply applying the Mandler test, in their eyes, in a more appropriate way, because the Mandler test, as I pointed out yesterday, includes factors like cultural factors, religious connection. If you lay more weight on cultural, and particularly the religious aspect, you could say, well, I regard, in my eyes, this is the Jewish race, effectively.
I understand that point, my Lord. If I may respectfully say so, the difficulty with it, my answer to it, is the Chief Rabbi is doing no such thing. He is not saying, I'm going to look at the Mandarin-Lee ethnicity of people by reference to a range of factors. He is focusing solely on one factor, which is not the same at all as Jewish ethnicity for Mandarin-Lee purposes. And the reason he's focusing only on that factor is because that is the religious commandment as he understands it. The point against me would be a strong one if there was some correlation between eligibility and ethnicity as defined in Mandarin-Lee, but there isn't, nor is the Chief Rabbi attempting to apply Mandarin-Lee. He's not interested, with the greatest of respect, in Mandarin-Lee. He's interested in Deuteronomy. That's the point.
But if he were, then it would be objectionable, would it? If he were applying the Mandarin-Lee test.
Of course, if he were to say to himself, I am going to decide who is a Jew from the point of view of ethnic origins as I understand Mandarin-Lee, then I could understand the argument against us. But that isn't what he's doing, and nor is it the result of what he's doing, as we've seen from the examples that have been given.
I find it a very difficult question because it's almost impossible, once one's talking of something like Jewishness, to avoid phrases like the Jewish people. I don't know whether Jewish or Orthodox Jews use that, but if they are, that sounds as if they're talking of an ethnic test. But you say when they say this is our definition of Jewishness, that is to be understood in a purely religious sense.
I say it all depends on context.
Yes.
The difficulty, I say, of this case is one has to identify what one means by a Jew. Does one mean in the sense of a people? Does one mean in the sense of someone who is a Mandarin-Lee Jew or is thought to be so by the person who's taking the action? Does it mean Jewish in a religious sense which covers all the different branches? Now, all of those questions, in my submission, may receive an entirely different answer. It depends on context. But in the present context, what the court is being asked to determine, and all the court is being asked to determine, is whether the criterion which JFS applies, which is the criterion which the Chief Rabbi applies, is to adopt a test of ethnic origins under the Race Relations Act. And all I need to say, is that that test is most definitely not a test of ethnic origins for all the reasons that I've sought to give.
But even if, the logic of your argument is that if you had a school which was open to Jews, defined on any religious ground by any of the denominations, that would be perfectly acceptable.
Indeed, and the problem, one of the problems of this case is that the gravamen, the substance of the grievance, is that JFS is too narrow in that it's failed to recognise persons who are recognised to be Jews by the Masorti and the Liberals and Reform. That's where we come into this case. The problem is that E's legal analysis has led the Court of Appeal, and can only lead the Court of Appeal, to adopt a legal test that makes it unlawful race discrimination even to be more inclusivist and to accept within the oversubscription criteria all children recognised to be Jewish by all the segments of the Jewish community. And the reason for this problem is because, as I say, for religious reasons, and only for religious reasons, the Chief Rabbi and the other authorities of synagogues, Masorti Reform and Liberal, all assess whether you are a Jew for religious purposes, I emphasise for religious purposes, purely by reference to status and not by reference to belief or practice.
In Lord Phillips' example of a religion which is only open to a particular race, the priest making the decision, or the authority, would be making it on two grounds, one religious and the other racist, or racial, or ethnic. And it's a question of fact, is it in a particular case, whether, if there are two grounds, one of them is ethnic, and if one of them is, then it's objectionable, even though there is another ground which is religious. No. Is that right or wrong?
In my submission, no, with great respect. What one has to ask, what is the distinction being drawn? What is the test? What is the criterion? And in the example put to me by the President and put to me by your Lordship, the criterion adopted is on its face a criterion that distinguishes people by reference to their race. Are they white or are they black? Are they British or are they foreign? And there is absolutely no doubt that that is to adopt a criterion which offends against the race relation. There's no problem there. By contrast, we say here, the criterion which adopted does not distinguish people by reference to their ethnic origins. It does not say, on the one hand, people whose ethnic origins in manhood terms is Jewish, on the other hand, people whose ethnic origins is, under manhood terms is not Jewish.
If there were a sole criterion, only children of Jewish mothers, then that would be okay if it meant Jewish in the narrow sense, but not if it meant Jewish in the Mandler and Lee sense. Is that right?
If the school adopts a criterion which purports to give priority not on the basis of a religious criterion, but expressly on the basis of a criterion which is an ethnic origins criterion, then it falls foul of the Race Relations Act. There's no doubt about that whatsoever. Our case is that the criterion here is not a criterion that distinguishes between people on the basis of their ethnic origins. It distinguishes between people on the basis of their religion. Some of those who qualify will have, or many of those who qualify will have Jewish ethnic origins, but it is certainly not the case that all people with Jewish ethnic origins do qualify, and the Chief Rabbi is simply not interested in that. That's my answer to your Lordship. The white supremacist church, I say, is not, with respect, a difficult case to deal with, and is plainly distinct from the circumstances of this case.
I mean, Lord Penny, if you're wrong, if the court feels right, then all oversubscribed Jewish schools, whether they're maintained or independent, and whatever Jewish denomination, are required to substitute for their definition of who are Jews who can be prioritized for education, people who they don't recognize as Jews, but by reference to how they practice or are interested to practice the faith.
Yes. People who, and your Lordship may have seen the difficulties that poses, and they are very real difficulties. They're difficulties of how do you devise a test that attempts to identify whether a person is a Jew in the context of a religion which has a clear rule as to who is a Jew. How do you deal with problems of synagogue attendance? How do you deal with ensuring that people turn up and don't just register and go away? How do you deal with the problem that religious obligation doesn't depend at all on synagogue attendance, depends for religious purposes on many other criteria? These are real differences.
This argument only goes so far because it would be equally applicable to a situation where the identification of who was or was not Jewish was plainly on a racial basis. Very easy to decide, or maybe quite easy to decide, depending upon the race, whether somebody qualifies or not. But the fact it's going to be much more difficult to adopt an alternative only takes you so
guess
far.
if the court comes to a clear conclusion that this is a racial, ethnic origins conclusion, then plainly this argument is not going to avail us. But when the court takes the difficult decision as to which analysis is correct, it surely, I submit, must be relevant to bear in mind the practical difficulties that are going to be caused to Judaism, and bear in mind that Parliament plainly has regarded in the Equality Act the need for careful consideration to be given to the practical problems that are going to arise. But I don't suggest, and I hope I made this very clear yesterday, our case is not based as a matter of law on the practical difficulties, but there are real practical difficulties, and there are practical difficulties that arise out of the approach that the Court of Appeal.
Your objection is not, as you say, that. It's the principal objection that none of these schools, whatever their denomination, should be required to educate people who they don't actually recognise as Jews.
Yes. I say that's a matter for them in the context of an Act of Parliament that expressly recognises faith schools, recognises an exception for faith schools which have been authorised by the Secretary of State, in the context of an instrument of government which recognises that it is the Orthodox community that is in charge of this school. That's our case.
Isn't the countervailing argument that religious freedom is there and is valued primarily in order that individuals can choose and give effect to their own convictions? It's an aspect of personal autonomy. And I mean, it seems to me the problem about Lord Brown's phrase, who they don't recognise as Jews, is that is actually giving a value to A's views about what B ought to be, whereas religious freedom is essentially about A's freedom to choose what A is. Of course, in the case of children and baptism, one perhaps recognises a slight contradiction, but maybe that's reconciled by the fact that parents at that stage have charge of their children and can, so to speak, select for their children. Isn't that a problem with the general
In my submission, no. There is no question in this case of any interference with M's right, indeed E's right, to believe what they like. The issue, and the reason why Article 9 is so important, is because Article 9 recognises, as I showed the court by reference to Hassan, the associational implications of this, that it is absolutely vital if one is going to promote the religious freedoms of individuals, that the institutions of the state respect the autonomy of the religious organisations of the church or the synagogue. And it is only through allowing the autonomy of those organisations that the religious freedom of individuals is going to be promoted. And what we are here concerned with is the admissions policy of a particular school which subscribes to Orthodox Judaism. And it must, I say, at root be a matter for Orthodox Judaism to decide which children it admits, subject, of course, to race discrimination law. But if one's in doubt as to the right answer, the autonomy of the religious authorities should be respected. That's my case. I've exceeded my time, but I hope properly so.
Yes.
Would it be possible to have a copy of the Scottish case that Lord Hope has referred to?
Certainly, we will provide a copy.
Thank you very much.
This is Percy, yes. I'm very much obliged.
Mr. Oldham?
I've got nothing to add. I'm grateful.
Thank you. Mr. Jeffrey.
My Lords, I appear for the United Synagogue, and when I heard this case had been listed before 9 justices, I thought that might have been a slightly generous allocation of judicial resources for a costs appeal. So I'll be very brief indeed, if I may, bearing in mind the court is actually here to deal with some slightly more interesting and important issues. The starting point in my submission is that the United Synagogue hopes that everything that I have to say on the costs appeal is first of all irrelevant, because if JFS's appeal is allowed, the issue in relation to costs simply doesn't arise, and the United Synagogue will invite the court to set aside the order for costs made by the Court of Appeal in any event. But if this court does reject the appeal brought by JFS, the costs appeal becomes a live issue. And as your lordships know, the Court of Appeal ordered the United Synagogue to pay 20% of the costs, not just in the Court of Appeal, but also before Mr. Justice Mumby. It would be interesting, I suppose, at least for the United Synagogue, to know how much money is in dispute and whether or not this appeal is actually a waste of everyone's time. But for no doubt good tactical reasons, we don't actually know how much money is involved in the 20%. Never mind. My submission is simply that the Court of Appeal went wrong in principle, both in ordering costs to be paid in the Court of Appeal and also ordering costs to be paid in respect of the hearing before Mr. Justice Mumby, not least because there was a protective costs order which was made by Mr. Justice Mumby, which wasn't subject to an appeal at any stage. Before very briefly making submissions on the facts, can I just identify what the United Synagogue says are the relevant principles? First of all, for parties to private law litigation, costs normally, but not invariably, follow the event. And what that means in practice is that, first of all, costs are decided at the end of the case rather than the beginning of the case. And secondly, that the loser of the case should expect to be paying the costs of the winner. And of course, the point of that general rule is to provide a very good incentive to the parties to think very carefully before they participate in litigation. The second principle, which the United Synagogue relies on, is that, as a starting point at least, public law litigation is conducted on the same basis. So a commercial developer that brings a claim for judicial review can expect to be ordered to pay a public authority's costs if they lose, and rightly so. And the reasons for that principle are exactly the same. But that second principle, at least in public law, now admits of some very wide exceptions indeed. So first of all, the vast bulk of public law litigation in this country is now dealt with in the tribunal system, where, save where there's unreasonable conduct, there'll be no order for costs at all. Even in the administrative court, if a party has legal aid, in practice, they have no risk of paying any costs, which was a matter dealt with by this court in its judgment relating to the protective costs order applied for by E at the instigation of the Legal Services Commission earlier this month. In other cases in the administrative court, the courts developed protective costs orders to ensure that meritorious claims on important issues of public interest can be brought before the courts without there being excessive cost risk. And the purpose of that is to obviously enable access to justice. And the protective costs order is quite a useful device for enabling access to justice, because it means that the party who's the beneficiary of the order knows what their cost liability is going to be at the start of the case. It will either be fixed to, say, nil or to some reasonable maximum sum. And it removes the potentially chilling effect of an unquantified and unquantifiable cost liability, thus providing certainty. And as your lordships probably know, the modern law of protective costs orders was stated in the Court of Appeal's judgment in the first Corner House case, the one that didn't reach the House of Lords, in which my Lord Phillips gave the judgment of the court. And one of the things that was mentioned in that case, I'm not going to turn it up because I think citation of authority on this appeal is probably a bad idea, is the Court of Appeal emphasised that once it has been made, a protective costs order probably shouldn't be disturbed unless compelling reasons can be identified. And that compelling reasons test was reconsidered last year in the case of Compton, both cases cited in my printed case, where the Court of Appeal looked at that test and they concluded that was the appropriate test because of the need to provide certainty to those who benefit from the protective costs order. And, of course, the reasoning behind all of that is, in my submission, pretty clear, because if a protective costs order is made at the start of a case and then it's revisited later in the case, whether by a first instance court or by an appellate court, without an appeal, the whole point of the protective costs order is then completely frustrated. And the protective costs order is there to enable a party to participate in the litigation, knowing in advance what their cost liability is going to be. But if they can't rely on it, then the effect is actually going to be worse than counterproductive. To give the assurance and then to whip it away at the end of the case is likely to have an even worse effect on access to public law justice than not making the order in the first place. And of course, that's what I submit has happened in this case. The third principle which I identify and which the United Synagogue relies on is that the ordinary costs order in respect of an intervener, even without the benefit of a protective costs order, is that an intervener will neither pay nor receive costs. And the court grants...
Repeat that, I beg your pardon. This is
I
the intervener's
apologise, my lord.
position.
That an intervener, even where the intervener doesn't have a protective costs order, will normally at the end of the case neither pay costs nor receive costs.
Yeah.
And the court, of course, grants permission to interveners to make submissions on the basis that they are hoped and expected to provide a useful role in assisting the court, but they're not parties. And of course, if interveners were routinely treated as parties and cost orders were made against them, then applications to intervene would be very rare indeed. Of course, I'd submit that's regrettable, but given that your lordships have, I think, 5 interveners, probably should say no more about that. The principle that there is generally no costs orders made against interveners holds good, even though in fact it is quite rare for an intervener to sit on the fence or appear before the court as a truly neutral amicus. Almost invariably, an intervener will be supporting the position of one party or another party to a greater or to a lesser extent. And the final principle which I identify as relevant in this area is that the normal order which is made in respect of interveners isn't an invariable principle. Where an intervener effectively becomes a party, that intervener can expect to be at risk of paying some costs if the position they advance is rejected by the court. And that's why my Lord Hope, speaking for the Appellate Committee in the case of Barker, which I also refer to in my printed case, ordered the Secretary of State to pay costs in a case where the Secretary of State appeared as an intervener in a planning case to defend the compatibility of his regulations with community law. And the Appellate Committee decided that the Secretary of State's regulations had not faithfully implemented the directive properly, and the Secretary of State was therefore ordered to pay a share of the costs before the Appellate Committee, but not, I'd add, a share of the costs below where the Secretary of State did not appear as an intervener. With those principles in mind, can I turn to the appeal in this case? At first instance, the United Synagogue intervened in the case on the express basis that it would neither seek nor pay costs. Its application was opposed, but it was granted by Mr. Justice Mumby. And it is common ground that the basis on which the application was granted was that there be no order, either in favour or against the United Synagogue in the action. Well, Miss Rose is objecting to that, and so if I could just turn up the documents. It wasn't recorded by Mr. Justice Mumby in the order that was eventually produced, but my understanding is that it is common ground that the United Synagogue intervened on that basis. Can I just show your lordships the relevant documents if it is in dispute? It's the Appendix Part 2, page 439. What your lordships have here is, these are Miss Rose's submissions to the Court of Appeal. On the issues relating to costs, and the relevant part I rely on is page 445 at paragraph 30. And in paragraph 30, picking it up about 7 or 8 lines down, the United Synagogue seeks to argue that it intervened on the basis that it would neither pay nor seek costs. That was the position in the administrative court, but it made no application for permission to appeal in the Court of Appeal on any basis, and no element of the administrative court's order gives it ongoing protection. In any event, its submissions to the Court of Appeal range far beyond those that were canvassed in its original application, and the true position is that costs in the Court of Appeal are at the discretion of this court. My submission is that I had always understood, certainly, that it was common ground between the parties that Mr. Justice Mumby had in fact granted permission to intervene on that basis. And because it was common ground, no application was made to Mr. Justice Mumby to correct his order under the slip rule. I would add that that part of the submissions which I've just read out are a little strange in suggesting it's the United Synagogue that should have made an application for permission to appeal. It's difficult to see what the United Synagogue was supposed to have been appealing against. The United Synagogue's submissions before Mr. Justice Mumby found favour. There was nothing for the United Synagogue to appeal. The issue of costs simply didn't arise before Mr. Justice Mumby because he was unsuccessful in his claims for judicial review. What I say, of course, is that if there was anyone that should have applied for permission to appeal in relation to costs, it was E, against that cost stipulation, the existence of which is common ground. The case then proceeded in the Court of Appeal, and no further applications, as E points out, were made in the Court of Appeal, and that is indeed the practice in the Court of Appeal, that where an intervener has appeared at first instance, no further application, unlike the position in this Supreme Court, is necessary. And that practice is detailed in an article written by Sir Henry Brooke about the practice in relation to interventions in the Court of Appeal, which, given that it's not codified, is the closest thing that anyone has to some guidance. Again, it's cited in my printed case. So, with that, I hope I can make my submissions on the cost issues very quickly. Dealing first with the costs in the administrative court, it is simply, in my submission, not clear why the Court of Appeal thought it proper to award costs against the United Synagogue at first instance, given that Mr. Justice Mumby had made a protective costs order. The Court of Appeal's reasons are in the appendix, part 1, at page, I think, 21. The relevant part of the Court of Appeal's reasons are at paragraph 4 of the Court of Appeal's cost judgment given by Lord Justice Sedley. They said the apportionment of costs reflects the relative active participation of the paying parties in what has been, for all practical purposes, a single appeal. In particular, we've taken the unusual course of requiring an intervener, the United Synagogue, to contribute to the claimant's costs. That's because the United Synagogue, by its leading counsel and with the agreement of the other parties, took on the principal role in opposing the claim and seeking to uphold the first instance decision, and then goes on to deal with the position of the Secretary of State and the school's adjudicator. Even if there had been an appeal against the protective costs order made by Mr. Justice Mumby, which of course there wasn't, the Corner House case suggests that a compelling reason should be identified before setting aside a protective costs order, and submissions to that effect were made to the Court of Appeal. The issue was dealt with in writing. For your Lordship's note, the submissions, which essentially repeat the points which I'm making before this court today, they're at Appendix Part 2, page 471. And the principled objection, of course, to what the Court of Appeal did, without giving any reasons for so doing, is that a protective costs order that can't be relied on is essentially of no value whatsoever, and no compelling reason was identified for setting it aside. In relation to the costs in the Court of Appeal, I'm not going to suggest, and it would be ridiculous for me to do so, to suggest that this court should start getting involved in who did what, who said what, and how much time different barristers spent on submissions in the Court of Appeal. As it happens, the United Synagogue says that it didn't take on a principal role, but disagreement with the Court of Appeal's judgment on that issue is not going to get me anywhere at all. The principled basis for intervention in the costs order made by the Court of Appeal in relation to the costs which were incurred in the Court of Appeal is, again, that the Court of Appeal did not consider the protective costs order that was made by Mr. Justice Mumby and that was not subject to an appeal. It was not appealed, and no indication was given by E at any stage that he considered it to be of no effect whatsoever. But even if that were completely wrong, the presence of a protective costs order is undoubtedly an important factor that the court should have considered when it was exercising its discretion. And if the court had said, we have considered the relevance of the protective costs order that was granted, but in the particular circumstances we have decided to set it aside, that would be one thing. It is another thing where the Court of Appeal simply don't mention it at all, particularly in circumstances where submissions have been addressed to it about that topic.
Sorry, I didn't understand the protective costs order extended to the Court of Appeal. I thought
the protective costs order, when it was applied to, was asked to be extended to the action. That was the terms in which it was applied for.
There can't be jurisdiction for a first instance judge to make a protective costs order in respect to an appeal.
I don't say there is jurisdiction for a first instance judge to make an order which binds the Court of Appeal of itself. However, what I do say is that the fact that an order was made is a relevant factor for the court to consider in the exercise of its discretion. And indeed, that's a matter which has been considered by the Court of Appeal in the Compton case. And again, I've cited it. I'm not going to turn it up because it will take substantial time. But what the Court of Appeal said in the Compton case is that where a protective costs order has been granted below, they would expect in the ordinary course of events that some protection would be appropriate in the Court of Appeal. It's a matter which goes to the court's discretion and which I say should have been dealt with, but unfortunately it wasn't dealt with at all. And that is why I say that the court's order in respect to the costs in the Court of Appeal was inappropriate and wrong in principle. And in those circumstances, I do invite this court to set aside the cost orders that were made against the United Synagogue, regardless of the outcome of this appeal.
if that's done, if the appeal fails and this is all relevant, your 20% then is thrown onto the other losing parties?
Yes.
Who aren't, as I understand it, are they responding to your appeal?
I don't believe so.
So, in fact, M is unaffected?
M was likely to be unaffected by the outcome of this appeal.
And how does it get shared out amongst the others?
That will be a matter for the court. In the circumstances where the Court of Appeal has made a very unusual costs order, where half is paid by the school, 20% by the United Synagogue, 20% by the Secretary of State, and 10% by the school's adjudicator, who didn't in fact attend any of the hearings, it is a difficult question as to how the court should re-exercise its discretion.
We don't know were any of the other interveners on a protected cost basis at any stage?
None of the other interveners, as I understand it, applied on that basis, save with the possible exception of the British Humanist Association, who also applied on the same basis, but no order for costs was made against them by the Court of Appeal. They didn't appear in the Court of Appeal.
But it is a very odd feature of this case, isn't it, that the United Synagogue chose not to rely on your services principally in the Court of Appeal, though no doubt you did an awful lot of work, but that actually they chose to instruct leading counsel. Now that's a very odd thing, isn't it? You wouldn't expect generally that an intervener would come along more powerfully equipped. We know just how powerfully equipped you were, than the actual respondent to the appeal.
Yes.
That's the odd feature about this, and I'm sure that's what paragraph 4 is getting at.
That is absolutely what paragraph 4 is getting at, and that is a discretionary judgment of the Court of Appeal, which I cannot hope to challenge, and which I don't seek to do so. What I do criticise is the absence of any consideration, first of all in respect of the position before Mr Justice Mumby. And of course, what this appeal is really about is it's not about the costs in the Court of Appeal, because the costs in the Court of Appeal are inevitably going to have been far less than the cost before Mr Justice Mumby. Before Mr Justice Mumby, as your ladyship will know, I appeared alone, and a protective costs order was granted, but the Court of Appeal gave no separate consideration to the position in relation to the costs below. So in any event, I invite this court to treat the costs, first of all, before Mr Justice Mumby, and secondly, before the Court of Appeal as separate issues. And secondly, in relation to the Court of Appeal, I don't say that the protective costs order bound, but I say it was a relevant factor which the court should have considered, but which there is, in my submission, no evidence that it did so. Unless your lordships have any questions on that issue, can I make some very brief points on the intervention. On the race discrimination issues, what the Court of Appeal has essentially held is that the religious test under Orthodox Jewish law governing whether or not a person is a member of the Orthodox Jewish religion is directly discriminatory on grounds of race. And of course, the consequences of this are not limited, as your lordships have heard, to Orthodox Judaism. The essentials of the religious status test, which are in issue, that is, dissent or conversion, are common to all denominations of Judaism. And I use the term denominations really for want of anything better, because the different denominations of Judaism are, in truth, I think, separate religions with a common core of shared beliefs, such as, for example, the belief that a person is inalienably Jewish, either by dissent or by conversions. And these types of schisms are by no means unique to Judaism. Contrast the Roman Catholic Church and the Free Presbyterians of Ulster. Both of them are Christian churches, but they are defined by their opposition to each other. In fact, most of the major world religions, Christianity, Islam, Judaism, share common beliefs, such as a belief in the scriptural value of the Old Testament.
Unlike the Anglican Church, which is defined by its internal oppositions.
Absolutely. They exist in Judaism as well, possibly. In answer to a question which was asked by Lord Brown yesterday about when these schisms started within Judaism, the answer, as the United Synagogue understands it, is the late 1700s and early 1800s, when the Reform movement was created in Germany. Needless to say, each denomination within Judaism believes, honestly and sincerely, that its formulation is the proper and accurate formulation of the faith. And what lies at the heart of the dispute before this court is a dispute between different Jewish denominations as to whose standards to be applied to conversion are the proper standards. And because there are several different faiths that each claim to be Jewish, it's important to get the terminology that's being used in the case correct, because it's very easy to confuse what is meant by Jewish. And so in this case, the case is being brought by E. E is a committed and sincere adherent to Masorti Judaism, and his son, M's, religious affiliations are the same, Masorti Judaism. And like Orthodox Jews, both E and M believe that Jewish status is transmitted down the maternal line or via a valid conversion. And that is why M has not personally sought to convert, because so far as he is concerned, he does not need to convert. He sees himself as a member of the Jewish religion because, according to the denomination which he adheres to, his mother's conversion is valid, and therefore he is inalienably, without more, regardless of whether he goes to synagogue every Saturday, regardless of whether he uses his PlayStation on Saturday morning, regardless of whether or not he eats bacon sandwiches. None of that is irrelevant. He is inalienably, so far as he believes, a member of the Jewish religion. Like Orthodox Jews, a Masorti Jew believes that M is a Jew, regardless of whether he practices the faith. The only relevant point of distinction between Masorti Judaism and between Orthodox Judaism is the different standards which are applied to the process of conversion. Orthodox Jews apply stricter and more exacting standards. Other denominations, in different degrees, apply less exacting standards. And that is the difference.
I mean, Mr. Jaffe, you say, paragraph 23 of your printed case, page 11, the last sentence, precisely what you've just said to us. The true issue between the parties is as to the proper standards to apply to conversion to Judaism, not an issue of race discrimination. Well, in one sense that's true, but actually that obscures the real issue before us, which is the deeper issue, which applies whichever of these denominations is, so to speak, right as to their internal dispute. Namely, do all of them, does the basic faith of all of them offend the Race Relations Act?
I entirely agree with my Lord's observation. And the interesting feature of this case is that E, a Masorti Jew who believes that status passed to his son by descent, has brought a case under the Race Relations Act, which has the effect, in many senses, of throwing the baby out with the bathwater.
Certainly.
And that
Sorry. I was wondering why, since the schisms you referred to took place at the end of the 17th century, and since presumably Orthodox Jews, were there no, if you could show that you had a Jewish, in the matrilineal line, ancestor before the end of the 18th century, why aren't you automatically an Orthodox Jew? Because at that stage there was no distinction.
you can.
Can so that, well, doesn't it follow then that almost all other Jews are quite likely to be Orthodox Jews in the eyes of Orthodox Judaism?
My Lord is right. Most people who attend, say, a Masorti or a Reform or a Liberal synagogue are also, if the Chief Rabbi was asked to rule on this issue, Jewish according to Orthodox Judaism. They may not believe in Orthodox Judaism. In fact, they may reject its tenets. But so far as the Chief Rabbi is concerned, they are members of the Orthodox Jewish faith, and they are also under a religious legal obligation to learn about, practice and follow the faith. They choose not to because they have different beliefs. But nonetheless, so far as the Chief Rabbi is concerned, they are members of the Orthodox faith.
So it's really for want of proof that they, and possibly want of interest, that they fail to qualify.
In reality, it is unlikely to be for want of proof. Often, the detailed genealogical studies are carried out in order to find out whether or not Jewish status can be shown. The London Beth Din spends much of its time dealing with those issues. But the practical situation is that many people who are adherents by their practices and beliefs to other denominations of Judaism will also be recognised by the Chief Rabbi as being Orthodox Jews. And that leads me on to the central question in the case, which is the reason why question, which is why the London Beth Din did not recognise that M is a member of the Orthodox Jewish religion. Now, the best way of illustrating why the London Beth Din and the Chief Rabbi's reasoning is not based on racial grounds is by way of straightforward example. The reason why M is not recognised as Jewish is because his mother's conversion was undertaken under the auspices of a progressive, non-Orthodox rabbi. That conversion is not considered valid by Orthodoxy any more than, for example, an Anglican baptism would be considered acceptable by the Catholic Church. And therefore, as a result, he is not recognised as Jewish by reason of his matrilineal descent. Equally, M himself has not carried out a conversion to Orthodox Judaism. And he has not chosen to do so. He could do so if he wishes, but he has not.
Is there any evidence that an Anglican baptism is not recognised by the Catholic Church? I think, unless you're familiar with this, it's another potentially very complicated area, I think, which it may be best to leave.
A baptism under the Scottish Church at one time wasn't recognised by the English Episcopalian Church.
One matter that is in evidence is that if a person wishes to join the Roman Catholic Church, having been an Anglican church, a process of conversion is required. Indeed, there is evidence before the court that the former Prime Minister, Mr. Blair, carried out exactly that conversion.
It's not baptism. It's not baptism.
No, it's not baptism. It's a process of conversion. So, take another example given by Lord Kerr yesterday. When a mother completes an Orthodox conversion after the birth of her first child, but before the birth of her second, the reason why the child is not a member of the Jewish religion, but the second child is a member of the Jewish religion, is due to the application of a religious test rather than a racial test. In practice, the two things...
That's difficult because, as Mandela says, you can become a member of an ethnic group by conversion.
Yes.
And so, I mean, it's quite arguable that ethnically the second child is a Jew and the first one not.
Absolutely. But the reason why for the difference in treatment by the London Beth Din or the Chief Rabbi is because of the application of a religious test. And the fact that you get a different answer depending on whether you're talking about the first child or the second child, even though, as my Lord correctly says, both children may be Jewish applying the test in Mandler, shows that it is a religious test which is in issue, and in my submission, not a racial one.
Well, I was suggesting the contrary, that actually one child might not be Jewish ethnically if you applied the Mandler test, and the other might be. Because ethnicity is under Mandler in part linked to practice, culture, religion. So, and it expressly states, Lord Nichols, that conversion can change your ethnicity.
In my submission, a court would have little difficulty if the first child was, say, refused a paper round on the grounds that he was Jewish. The court would have no difficulty in saying that that was a decision which was made on ethnic grounds and because the child was Jewish in practice. Can I just turn briefly to the issue of indirect discrimination? The essential question is, of course, why a Jewish school is refusing a committed, sincere member of the Masorti Jewish Synagogue a place, whilst giving places to children who are members of the Orthodox Jewish religion, but may know absolutely nothing about and care very little for Orthodox Judaism. And as part of my answer, I would like to invite your Lordships to look briefly at the statement of Mr. Jacobs. And I understand that Miss Rose objects to it, and what I will invite your Lordships to do, and I don't think she objects to your Lordships looking at it, is to look at the statement and decide, depending on the submissions which she makes, whether or not to admit it in evidence in due course. Your Lordships can find it behind the case for the third intervener.
It's in the men. It's next to your case, yeah.
My Lord, yeah. I wish to draw your Lordship's attention to two passages, very briefly. First of all, paragraph 7. Where Mr. Jacobs sets out the importance in the Jewish faith of the religious obligation to teach children about the Jewish faith. And then in paragraphs 9 to 11, Mr. Jacobs explains that inevitably that means that many children to whom Jewish schools would want to provide a Jewish education may well know little at the point of entry about the Jewish faith, and indeed it's perfectly possible they may care little for it. But that is something which is intended, deliberate and intentional on behalf of the Chief Rabbi, because the Chief Rabbi wishes to take children who are members of the faith and teach them about it in the hope and expectation that they practice it. Lord Panic was asked yesterday about the extent to which the court should be balancing the religious beliefs and the interests of children in the position of them with the religious justification that has been put forward for the admissions criteria. All I wish to say about this is that in the case of Judaism, as opposed to another faith, the religious justification for the admissions criteria which are adopted is, in my submission, particularly strong. And the reason for that is that, unlike, say, Christianity, Judaism is not a proselytizing faith. It does not seek to convert everyone, whether by its schools or otherwise. As a result, the belief of Orthodox Judaism is that only those people who are members of the religion need learn and obey Jewish law. And by non-Jews, the Chief Rabbi would, of course, include M in that category. And so that is, of course, because non-Jews who live a good life are believed by the tenets of the Orthodox Jewish faith to be able to achieve salvation. They need not practice Judaism, they need not learn about it, and they need not live their lives according to the tenets of Judaism. And so in those circumstances, where there is an oversubscribed Jewish school, then it's a zero-sum game. For each child which is admitted to the school who is a member of the Jewish religion, the school necessarily has to reject another child who is a member of the Jewish religion. And in those circumstances, the religious obligation, which is on Orthodox Jews, including the Chief Rabbi, to educate members of faith in the faith, is frustrated. And in those circumstances, it's my submission that there is a legitimate aim, and the means adopted are entirely proportionate. My Lords, those are the submissions which I wanted to make on behalf of the United Synagogue, unless your Lordships or your Ladyship had any questions. I'm great.
Thank you very much. Yes, Mr. Linden.
My Lords, my Lady, we appear for the Secretary of State for Children's Schools and Families, but our arguments also reflect the views of the Government Equalities Office, which, as the Court will know, is the government department responsible for its strategy on equality, and which was concerned with the introduction of the Equality Act 2006. You will have seen from our printed case that we agree with the analysis of the law submitted by Lord Panic and indeed by Mr. Jaffe, and for that reason our submissions will be brief. You'll be relieved to hear. If I can identify the aims of the submissions we put before the Court, they are firstly to assist the Court with the wider context of the claim and the effect which it may have, and I emphasise may have, on other schools, and to look at matters of general legal principle raised by this case. Secondly, it is not our objective to enter into the fray as between the parties to the actual dispute. We only look at this particular case with a view to seeing what the wider implications may be. The submissions that I'm going to make, therefore, are divided into 5 sections. Firstly, a brief look at the impact of the Court of Appeal judgment. Second, 3 short points on the question of direct discrimination. Third, 3 short points on the indirect discrimination issue. And fourth, the human rights arguments, stroke the arguments of the British Humanist Association. And then fifthly, I'll make a short point on costs. Can I turn to the question of impact? I stress that the points that I'm going to make are not with a view to saying that the position is calamitous, and because it is calamitous, some different analysis of the law should be adopted. That line of argument would be foolish. I make the point simply so that the Court sees, I imagine it sees it already, the context within which this dispute arises, but also because some of the arguments may go to the question of indirect discrimination, particularly on the analysis advanced by Ms. Rose and Mr. Allen. So that's the limit of the reasons why I make these points. I draw attention, if I may, to paragraphs 4 to 8 of our printed case, setting out the position in relation to Jewish schools. If I can invite you to turn that up. Those paragraphs, and I don't propose to read them back to the Court, set out the data in relation to the number of faith schools, and I've asked to be put before the Court copies of the up-to-date statistics so that you can see the numbers of schools and how they're broken down according to designation. I don't propose, given the time available, to dwell on that data. You have it there if you wish to look at it. But you will have gathered from our printed case, based as it is on Ms. O'Sullivan's witness statement, that if one turns to the direct discrimination finding by the Court of Appeal, the immediate impact is on Jewish schools, virtually all of which, or certainly all of which we're aware of, apply membership criteria. There is a potential impact, I put it no higher than that, on 4 Sikh schools, because Sikhism is also potentially coterminous with ethnicity. But they at the moment do not apply membership criteria, and therefore I put it no higher than that.
Sorry, they don't at the moment do what?
Apply membership criteria. They apply criteria based on practice.
They apply what? I can't hear very clearly.
I'm sorry. Criteria based on practice, I'm sorry.
It's no good putting those microphones there. They don't operate at this end of the court.
Right.
You'll just have to speak clearly.
I'm obliged. The direct discrimination finding...
Are these Sikh schools, in fact, oversubscribed?
I'm not able to help. There's no evidence before the court on that subject. The direct discrimination point doesn't, it should be pointed out, affect other faith schools, such as Catholic or Muslim schools, because there isn't the link between ethnicity, or the close link between ethnicity and religion, as the court will be aware. There is, however, when it comes to indirect discrimination, a potential issue for other schools, for example, Catholic schools, which almost universally require baptism as a condition in relation to oversubscription, and many of which require baptism to have taken place within 12 months of birth, as required by canon law, in order for that condition to be satisfied. And I draw attention to that because I understand that arguments are going to come forward to the effect that one's religious status, if one is Jewish, is not something one could choose. Similar arguments might be put in the Catholic case, that infants who are baptised, of course, don't choose that course, albeit I take Lord Mance's point, that the parents exercise choice in that matter.
Nothing to do with race discrimination, though, is it, on any view?
Agreed. That's why I put it in terms of it becomes relevant in relation to indirect discrimination. The third point in relation to direct discrimination focuses on the British Humanist Association's submission, because if I understand the arguments correctly, they appear to be contending that membership criteria alone cannot be decisive. If they are to be used, they must be combined with questions of belief and practice. The point I make about that is that, with respect, it misses the point in the present case, because a combination of membership criteria with criteria relating to belief or practice will not assist children in M's position, because they will not be able to satisfy the membership criterion. And hence, the real issue is whether there should be a complete ban on membership criteria when it comes to Jewish schools, and indeed that is the position contended for by Ms. Rose, and the position adopted by the Court of Appeal. I'm relieved to say that is not my mobile phone. That's the impact of the direct discrimination finding. As regards indirect discrimination, there are two potential respects in which the Court of Appeal's judgment impacts other schools. Firstly, insofar as the Court of Appeal said that if a provision, criterion or practice, ostensibly racially or religiously neutral, impacts or is correlated with an ethnic group, there is necessarily indirect discrimination. There cannot be justification, and I'll come back to that passage. If that is right, and I'll submit in due course that it's wrong, that potentially has an impact for all sorts of religious schools, because, of course, as the court will appreciate, a requirement that a child be Muslim or practicing the Muslim faith applied in an area which is predominantly Pakistani, for example, will advantage Pakistani children and disadvantage within that area non-Pakistani children. Similarly, a Catholic requirement that there be baptism would advantage potentially Irish children in Kilburn and disadvantage non-Irish children. Hence, that point in the Court of Appeal's judgment, paragraph 45, has potentially wider implications, but it appears to suggest, on one reading, that there can never be justification of indirect racial or religious discrimination. The second area where there is potential impact is that, of course, at the heart of M's argument on proportionality is the proposition that membership of a religious group can never be a permissible criterion where oversubscription is concerned. That clearly has implications for Jewish schools, but it has possible implications for other schools. For example, Catholic schools applying a condition of baptism. There would then be debate about whether that was a membership criterion, and if it was, on this argument, the conclusion would be that there are difficulties in justifying it. So that's how the indirect discrimination aspect potentially impacts. Thirdly, in relation to this section, can I then turn to the practicalities? Again, I don't say the practicalities should be considered simply with a view to rejecting legal analysis, but I do, with great respect, counsel the court to submit the court should adopt caution in relation to the arguments put forward, to the effect that it's very simple. One should simply adopt belief-based or practice-based tests in this context. And that isn't, with respect, very simple, for reasons which I'll briefly develop. I leave the Jewish organisations to speak of the particular difficulties caused for those organisations. But even as a matter of general principle, one can immediately see that these issues, this approach does not solve the problems. This is a case concerned, obviously, with oversubscription situations, and therefore decisions as to whether child A or child B should be given a place. Clearly, membership criteria per se will cause children who are non-members to be disappointed. But equally, criteria based on practice or belief will cause those who are not thought to be sufficiently believers or sufficiently practicing to be disappointed. So Mr. Jaffe used the phrase zero-sum game. It can be applied in this context too, that all that happens if Malone from Miss Rose succeeds is that you have different people disappointed for slightly different reasons. So practice-based criteria are not the panacea in that respect. But there are other respects in which practice-based criteria are problematic. One can at least say, in relation to membership criteria, that they are objectively they are objectively verifiable. And one can also say that if, for example, a Protestant applies to a Catholic school and is told, we're not going to give you a place because you're not a Catholic, whilst they may be disappointed, it is easier to understand rejection in that situation. We're a Catholic school, it isn't that surprising, we don't give priority to Protestants. Contrast tests based on belief and practice, immediately one encounters difficulties of verification. The child's parents say that she goes to Mass every week. The priest says it's 3 times out of 4. There is immediately a problem of verification. In terms of the feelings of the children, again, and of the parents, here the statement to the parent is not, we're a Catholic school and you're a Protestant. It is, we're a Catholic school, we accept that you're a Catholic, but we reject you because you're not Catholic enough. And of course, that statement of itself can be equally wounding, because the riposte is always, so you're saying I'm not a good enough Catholic. So I don't make any of these points to argue that faith-based or practice-based criteria can never be applied, but simply to point out that they do not provide an easy answer in this case or in any other case. Those are my submissions on impact. Can I turn then to a little legal analysis? Firstly, on the question of direct discrimination. Much of the ground has been covered on that, and I don't propose to rehearse it. The court has our printed case. But if I may, I just want to look at the statutory framework and to make a couple of points leading up to that. As far as we support the analysis advanced on behalf of the school, as we characterise the case, it operates in the following stages. That the statement that a person is a Jew may be a reference to their religion, or it may be a reference to their ethnicity, or, of course, adopting Lord Clarke's point, it may be a reference to both. To ascertain what is being referred to, you have to ask, what are the characteristics of that person which are being referred to by the maker of the statement? Now, the same is obviously true, we would submit, where the statement is that the person is not a Jew. Hence, adopting Lord Clarke's analysis, where the statement has been made, there is a factual inquiry as to which characteristics are being referred to. Now, pausing there, contrast immediately a situation where somebody says, you're black. There is no need for a further factual inquiry as to whether that is a reference to a racial characteristic. And then as to the question of the factual inquiry, the context, as has been discussed, is important. If a member of the BNP is saying, we're not having you, you're a bloody Jew, the answer to the question whether that's a reference to ethnicity or religion may be easy. We would submit that if a religious authority is asking the question, are you a Jew, for the purposes of deciding whether you should have priority for a faith school, again, notwithstanding the many arguments there have been in this case, the answer is easy. The Chief Rabbi is referring to the religious characteristics of M, or the lack of them. That is, the fact that no one in his matrilineal line was an Orthodox Jew, and he has not undergone a valid conversion. The Chief Rabbi, we would submit, is not referring to the ethnic characteristics of M or to those of his mother. Thirdly, and importantly, nor, because this is the main charge that is put against this argument, nor is the Chief Rabbi referring to M's ethnic characteristics, but saying it's permissible for me to do that because I'm doing it for religious reasons. Now, if one turns to what I would submit Ms. Rose's case has to be, it has to take one of two forms. Either she has to argue, by analogy with the decision in James and Eastleigh Borough Council, that Jewish ethnicity and Jewish religious status are one and the same. There is no difference when one refers to retirement age, to calling it retirement age or calling it gender. Similarly, there is no difference between saying you're Jewish and that being religious or and that being ethnic. That is the first possible line of argument open to her, we would submit. But with respect, we would submit that it's impossible for her to get home on that line of argument for the reasons advanced by Lord Pannick and Mr. Jaffe. And if I may say so, for the reasons brightly illuminated by Lord Carr in his example of the mother with two sons. It sounds like the beginning of a parable, and in fact, it is, with respect, an example which clearly illuminates the point that's made to the effect that ethnicity and religion are not coterminous in the case of Judaism. So in our submission, that line of argument isn't open to Ms. Rose. The second potential line of argument is to accept that there may be a distinction between Jewish ethnicity and Jewish religious status, but to seek to draw the line in a different place, and to argue that the reference to the statement a person is a Jew is permissible if it refers to their belief or practice, but not permissible if it refers to their membership. Now, again, we would say that immediately encounters difficulties just as a matter of principle, because the Jews are immediately recognisable as a religious group as well as an ethnic group. For the reasons I've advanced, those two groups are not coextensive, and it is therefore meaningful to speak of membership of a religious group in the case of Jews. That is her, in my submission, fundamental difficulty in terms of drawing the line, if it's accepted that Judaism is not coextensive in terms of ethnicity and religion. But her second difficulty is that is not where the line is drawn in the legislation, and that's where I wanted to go back, if I may, to the Equality Act, and to make 3 points in relation to that. The Equality Act in volume 9 of the appendices. tab 71, and in particular page 33, if I can ask you to turn that up. There are 3 points that I wish to make in relation to the Equality Act. The first, if I can characterise it in this way, is really the telescope point. From what end of the telescope should the court be examining this problem? Should it be starting with the Race Relations Act and asking whether it is direct race discrimination? Or should it, as we contend, be looking at the Equality Act 2006 and asking whether this form of decision-making was authorised by Parliament through that legislation?
Does that mean that something which could have been race discrimination before 2006 ceased to become it in 2006?
I don't go that far, my lord. All I say is that in terms of, in approaching this legal problem, what the court has is really a contest between parties saying that, well, what we're doing is authorised by the Equality Act, and parties saying what you're doing is prevented by the Race Relations Act. In terms of the legal analysis, my submission is one should start with the Equality Act for reasons which I'm about to advance. My lords, the reasons I advance are as follows, that in this case, the Equality Act obviously comes on the scene, if I can put it in those colloquial terms, in 2006. Long before that, of course, you have in the order of 6,000 to 7,000 faith schools, and you also have, as the court will have seen, those schools being designated as schools of a religious character. And without going into substantial detail about it, even before the Equality Act 2006, schools which were designated as having a religious character then were subject to particular provisions under the School Standards Framework Act 1998. For example, there were particular provisions dealing with the composition of their governing bodies, dealing with their instruments of government, dealing with the contents of the curriculum vis-à-vis RE education, dealing with the employment of staff, and so on. So you had, as it were, a system of faith schools with a particular statutory regime applied to that group of schools, which were the designated faith schools. What you then have in my submission is the addition of a further layer in the form of the 2000 Act, which, as the court has seen...
2006 Act.
2006 Act, I'm sorry, did I?
Yeah.
Which, as the court has seen, if I can put it in colloquial terms, plugs into that system, because the exemptions which we say this case falls within are exemptions applicable to those designated faith schools. And that one gets that from section 50, if I can ask you just to glance at that. Page 37. That the exemptions under 51A apply to schools designated under the 1998 Act. Now, hence my submission that the way the court should be asking the question is to start with the 1996 Act and say, well, this was an act clearly intended to apply to schools, including the designated Jewish schools. And the question is whether it is an act which was intended to authorise the decisions that those Jewish schools are making, or whether an act which intended its authorisation not to apply to Jewish schools, but to apply to all other designated schools. That's how I'd invite you to ask the question. I don't say that that's the end of the inquiry, because, of course, you may conclude that it didn't intend to authorise these decisions because it had previously enacted the Race Relations Act. But in terms of emphasis, that is the approach which I'd invite the court to adopt. Can I then turn secondly to the question, well, what is it that the 2006 Act authorised designated schools to do, and ask you to go to page 33. The court's seen through Lord Panic's submissions that the prohibition under section 45 applies to religion or belief, and again that formulation is used, religion or belief. The first point I adopt, already made by Lord Panic, I appreciate, is that the concept of religion, being of a religion, if one looks at 45.2, clearly embraces the concept of belonging to a religion. And conversely, the authorisation in relation to discrimination under section 50 therefore authorises discrimination based on belonging to a religion. Hence my first point, that in terms of drawing the line, the legislation does not draw the line at the difference between belonging to a religion and belief or practice. It clearly draws the line somewhere else and clearly authorises decisions based on belonging to a religion or belief. And of course, we submit that that is the nature of the decision taken in this case. Ms. Rose would be in a stronger position if it said religion and belief. She would be in a stronger position if it said belief and or practice. But with respect, that isn't what it says. The second area that I wanted to take in relation to the specific text of the legislation is, I hope to assist the court to see where questions of practice fit into this scheme. Because if the submissions you've heard thus far are right, you have essentially in relation to direct discrimination an authorisation of discrimination on the grounds of the membership of the religion and the belief that the individual holds, but no explicit authorisation of discrimination in relation to the way that they practice their faith. How does practice of faith fit in? Answer, not under the heading direct religious discrimination, but under the heading indirect religious discrimination. And that's 45.3. The case law thus far establishes that where, for example, the problem arises because an employee cannot work on a Saturday, or because the employee wears particular religious clothing, or they can't attend school on a Friday, that is not regarded as direct discrimination on the grounds of membership of a religion or on grounds of belief, but as a neutral criterion which has a disproportionate adverse impact potentially on particular members of a religious group. And I don't propose to turn it up, given the time available, but the court has in the authorities at volume Roman 15, tab 110, the Liddell case, which concerned, it's quite a well-known case, it concerned a registrar working for Islington Council who was an evangelical Christian and refused to officiate in civil partnership ceremonies. The question was, is that direct discrimination because it's related to her Christianity? The answer was no, it isn't, because the manifestation of her belief is the problem. It is indirect, it's potentially indirect discrimination. That was the way it was analysed. My third point in relation to the Equality Act is so I wasn't going to ask you to look through the case at this stage. I was going to invite you to consider it in due course.
There's a Court of Appeal case, isn't there, about about the teaching assistant.
That's right,
which is
yes,
possibly a rather better example.
Yes, Asmin Kirklees.
Yes.
I gave you that example because that's in the materials you've already got.
Liddell is going to the Court of Appeal.
Yes, Ms. Robin told me Liddell's going to the Court of Appeal. So the third point I was going to make on the Equality Act is simply the observation that it would, in my submission, be very surprising if Parliament, having extended this authorisation, the precise contours of which we've just considered, to designated faith schools, did not make clear in the Equality Act that that authorisation was not being conferred on Jewish schools because their approach is directly race discriminatory. One, in my submission, would have expected that to be made clear, given that it's such a controversial and sensitive point. Now, there are other points to that effect. I don't develop them in detail, but the essential point developed in the cases of all of those who are on this side of the argument is that there are other provisions which, as it were, give special treatment to religious organisations. Section 57 of the Equality Act is one. Again, it would be very surprising if Jewish religious organisations were not entitled to the benefit of that authorisation. Those are my points on direct, the legal analysis for direct discrimination. May I turn then to indirect, where again I seek to make 3 points. The first is about the effect of the premise on which this argument proceeds. The premise, of course, is that it has been accepted that the criterion applied by JFS in this case was not an ethnic criterion, it was a religious criterion. And that then has consequences for the analysis, which I imagine the court has already seen, but if I may, I'll just briefly outline them. The first, with respect, is that it immediately disposes of the Court of Appeal's point about the relationship between the impugned criterion and Jewish status. And may I come now specifically to that point? It's paragraph 45 of the Court of Appeal's judgment. It's Appendix Part 1, page 17. This is the passage that we looked at yesterday with Lord Panic. The objection that the admission criteria are explicitly related to ethnicity and therefore cannot form any part of a legitimate aim. Well, of course, one would accept that if on point 1, the direct discrimination point, it's been held that membership of the Jewish faith is a directly race discriminatory criterion, then you won't get any further by saying, in the context of an indirect discrimination argument that doesn't arise anyway, by saying, well, we rely on the fact that we discriminate directly. But if the premise is that the explicit reference is to a religious criterion, then in my submission there's absolutely no reason why one cannot go on in the usual way to consider disproportionate adverse impact and justification. So that's the first consequence of the premise. The second consequence, and third consequences, which I'll deal with very briefly, are that now one is in a position, and in my submission one ought at least to have an eye to this question, to look at the impact on other schools if the arguments in this case on behalf of M are accepted. Because now we are in a situation where religious criteria are being applied in a particular religious school, and questions begin to arise, well, what is the position vis-à-vis the Catholics and others who adopt different approaches? In the case of the Catholics, approaches which might be characterised as membership approaches and so on. And one in my submission therefore has to have an eye to those problems without necessarily resolving them. Lastly, in relation to this point, the Article 14 issues then, of course, potentially come into play, because whilst of course one can't say under Article 14 the justification involves direct race discrimination, now we're not concerned with that. We're concerned with potentially direct religious discrimination, and other religious groups become comparable, and all of those questions open up. That's my first point on indirect, the implications of the premise. My second point involves us going back, if we may, to the Equality Act, and can we just do that? It's volume 9 of the authorities, and we're concerned again at page 33. Now, just so that the court sees where I'm going, the point that I wish to make, by reference to the concepts of indirect discrimination in relation to religion and then in relation to ethnicity, are firstly that there is a high degree of artificiality about considering this case as indirect discrimination under the Race Relations Act, and secondly, connected to the first point, that the reality of this case is that it is a complaint about disadvantage to a religious group and advantage to another religious group, which situation is expressly authorised by the Equality Act 2006. Developing that point, if I may, at page 33, section 45.3, the court sees the concept of indirect religious discrimination. The court sees that that involves the application of a provision, criterion or practice, which is applied equally to persons not of the complainant's religion or belief, which puts the complainant at a particular disadvantage, the complainant's group at a particular disadvantage compared with others who are of a different belief, and which puts B specifically at that disadvantage. And if those are the facts, then justification arises. Now, those are provisions clearly intended to deal with circumstances where the provision, criterion or practice has a disproportionate adverse impact on a particular religious group and, as conversely, advantages a different religious group. Now, my submission is that if this is not a direct religious discrimination case, which it most probably is, then that is the true characterisation of this case, that what you've really got here is an advantaged religious group, Orthodox Jews, and a disadvantaged religious group, namely those who are not Orthodox Jews. And the justification question is then, is it proportionate given the disadvantage to the disadvantaged group and, of course, the particular individual? And that is a particular question asked in a particular context, to examining proportionality against a situation of religious disadvantage. But very importantly, the Equality Act, through Section 50, provides that in the context of designated faith schools, those arguments do not arise because, of course, as Parliament recognised, decisions by faith schools may well disadvantage religious groups. But those are not questions that the courts are asked to engage with, because the Equality Act is saying that may be so, but it is authorised.
I mean, you say that by definition under this Act, indirect discrimination can't arise.
Indirect religious discrimination can't arise, yes. And what I'm submitting is that the true analysis of this case is that if it's not a direct religious discrimination case, the reality of it is it's an indirect religious discrimination case where you've got an advantaged religious group and a disadvantaged religious group.
For which this Act, in respect to designated schools, explicitly authorises.
Exactly. So the unhappiness, and it's immediately acknowledged by the Secretary of State that these decisions cause unhappiness, but of course it's pointed out that different decisions cause unhappiness to different people. The unhappiness in my submission And disappointment is really consequent upon membership of a religious group. Now, if we can then go to the Race Relations Act and see how the case plays out, and I stress that I'm not making these points in order to shut out the question of justification. I adopt Lord Panic's approach on that as well. The Race Relations Act is behind tab 73. Of course, under section 1 capital A, as you saw yesterday, it has a very similar, if not identical, concept of indirect discrimination, but here one is not concerned with the impact on different religious groups, one is concerned with the impact on different racial groups. Now, if one looks at this, steps back and looks at this case, is this a case where it can realistically be said that the disadvantage that the court is concerned with is a disadvantage to the Jewish ethnic group? And in my submission, looking at the case realistically, that isn't the nature of this case. The criterion which says you must be recognised as a Jew by the Chief Rabbi is one which clearly advantages those who are of the Jewish ethnic group. Because the ones who will have greatest difficulty in satisfying it are, of course, those who are not ethnically Jewish. That's my point about the artificiality of Ms. Rose's case, because with respect to her, what she's trying to do is to force the square peg of arguably indirect religious discrimination into the round hole of the Race Relations Act. Now, as far as justification is concerned, I also, if I may, I think it was Lord Phillips questioning to Lord Panic yesterday, if I may say so, that an important question was asked. Look, the effect of Lord Panic's submission, if one forgets about the written argument, is that one adjudicates proportionality in the abstract. But of course, what actually has to happen under this legislation is one has to adjudicate proportionality against the disadvantage which has been identified. And in this case, the disadvantage, as I've submitted, is a disadvantage to an ethnic group of which the claimant, M, is not a member. And if one asks the question, is it proportionate to have a criterion which excludes people who are not ethnically, or disadvantages people who are not ethnically Jewish, and one sees that the criterion is being applied with a view to considering entry into a Jewish faith school, then in this context one doesn't find the disadvantage that surprising or shocking. There may be greater room for argument in the religious context, of course, but there Parliament has expressly said that that level of those disappointments are inherent in the faith school system. Those are my points on the artificiality of it. But what I point to, of course, is that really Ms. Rose is relying on the disappointment from in religious terms of a religious group to supply an argument in the context of legislation which is concerned with the disappointment in ethnic terms of an ethnic group. The third point I make in relation to indirect discrimination is on the merits of the justification argument. And again, I don't propose to add a great deal to Lord Panic's submissions. The court has seen the statement of Ms. O'Sullivan. In summary, the position is as follows, that there is a spectrum of faith schools within the state system, and indeed, of course, one has to bear in mind that the arguments, particularly on direct discrimination, may apply to the private school system. There are 60 Jewish private schools. Some faith schools seek to educate the wider community, typically Church of England and Methodist. Others say that as a minimum, you have to satisfy conditions such as baptism, which might be characterised as membership conditions, and then apply secular criteria. I don't know if the court saw the example of St. Edward's on Newsnight, the view taken at St Edward's apparently is it would be wrong for us to judge whether somebody's a good Catholic. They must be a Catholic. It would be wrong to judge whether they're a good Catholic. What we do is we then draw lots, provided you've got the baptismal certificate. Then there are others who are concerned with membership and practice and then apply differing tests of differing degrees of scrutiny of the practice of the individual. And then there are others which are not concerned with membership as such, but focus on practice. Now, the position of the Secretary of State is that all of those types of schools have a place within the school system, all contribute to its diversity, and all increase parental choice. Very importantly, that position is underpinned by the proposition that it is not appropriate for the government, or for the courts for that matter, unless it's clear that the conduct is unlawful, to become involved in decisions about who should or who should not be counted as a member of a particular faith or a good member of a particular faith. So those are the only points those are the points I wanted to make on indirect discrimination.
That's slightly inconsistent with an assertion that this increases parental choice. That could be broken down and investigated, but I understand the Secretary of State's attitude basically to be the same as the Jewish Free School or the United Synagogue, that the religious test must be given an absolute priority.
Well, the Secretary of State's position is that the Jewish Free School should be permitted to give the religious test an absolute priority, of course, subject to the views of this court as to whether, in so doing, they discriminate directly on grounds of race. Can I turn then to the Human Rights Act arguments and or the arguments of the Humanist Association? I don't propose to spend a great deal of time on that. Again, I adopt Lord Panett's submissions, but the Humanist Association argument, it appears, will be that there can never be membership criteria in isolation. They have to be combined with practice. My submissions in relation to that are that this is not really an argument which arises in this case for the reasons that I've given. We're concerned with a case where, if membership criteria play a part at all, children in the position of M are disadvantaged. Secondly, as I understand it, Ms Rose is not advancing a wide-ranging submission to that effect, and the court will have seen in Mr Justice Mumby's judgment, page 94, paragraphs 281 to 285, I don't invite you to turn it up, that was the stance that was taken, that it would be strange for the court to decide the case on a much wider-ranging basis than the basis that was actually being argued by the claimant in the case. Thirdly, I would submit that it is one thing to make a ruling in the context of faith schools generally, and with one eye to the potential implications, and I do no more than draw attention to the potential implications in this case. It's quite another to rule on cases which are not before the court, where religious groups are not represented, do not have the opportunity to present evidence, and do not have the opportunity to make submissions as to whether their particular way of going about things is necessarily unlawful. So for those three reasons, I would invite you not to adopt the course proposed by the British Humanist Association. I would submit, obviously, that in any event, the submission that you cannot, under any circumstances, confine yourself to membership is wrong for the reasons that the advocates have given thus far. Lastly, in relation to costs, the court will have seen that there is can I put it in these terms in the context of this case, a small issue as to costs. The Secretary of State challenges the decision of the Court of Appeal to order 20% of the costs be paid by the Secretary of State. I'm simply not going to develop that argument at length. I adopt Mr Jaffe's submissions as to the analysis of the law. My submission is that the Secretary of State, albeit joined as an interested party rather than an intervener, joined by the claimant, serving the public interest in putting the widest perspective before the court, ought not, in my submission, to be penalised in costs for doing so, and hence, even if the appeal fails, we'd invite you to set aside that part of the court's order.
So you've got an appeal against cost too, have you?
We do not have a formal appeal. We've raised the issue. We inquired as to whether it was necessary to put in a formal appeal and were told no need.
Given the number of references in Mr. Justice Mumby's judgment to the arguments of Mr. Singh, it may very well be that a rather similar consideration popped in as did...
Well, I take that point. Complementary, the way the case has gone is complementary references as always to Mr. Singh's submissions, highly condemning and disparaging references to mine, and deservedly so, of course. But so I take the point, and I don't therefore make any further submissions on the cross issue. Unless there's anything I can assist the court with, those are submissions.
No, thank you. Mr. Woolston.
Yeah.
My Lords and my Lady, I appear for the Board of Deputies of British Jews, together with Mr. Grudzinski and Professor McColgan. In view of what Baroness Hale said a moment ago, I hope that means that we are appropriately, if not powerfully, equipped. First and foremost, the Board wishes to thank the Court for permission to intervene and to make written and these very short oral submissions to it. And in the limited time I have available, I do not propose to repeat what we've said in our written submissions, but rather let me begin by setting out why the Board has intervened in this case at this time and what its precise position is. As the Court will have appreciated, the Board is the representative voice of British Jewry, consisting of deputies drawn from a broad cross-section of the Jewish community in the United Kingdom, other than some extreme Orthodox groups whose views on this issue would not in any event differ from those of the United Synagogue. And the function of the Board is to protect and promote the welfare and rights of the entire Jewish community in the United Kingdom. The Court might be familiar with the aphorism. Indeed, you may think, having heard arguments so far, it is in fact an axiom, that where there are two Jews, there are three opinions. That is certainly true with regard to the subject matter of this case, and there is no doubt the decisions of Mr. Justice Mumby and indeed of the Court of Appeal have caused controversy both within the Jewish community as well as without. And the Board is here, therefore, to give the Court its perspective on the issues raised in this case from, and I emphasise this, a cross-communal and multi-denominational standpoint. Because as you will appreciate, the Board's deputies are drawn from Orthodox and also Masorti, Reform and Liberal religious congregations, as well as indeed other bodies. And as I will endeavour to explain to the Court, there are matters on which those various denominations are agreed, and matters on which they disagree, you will not be surprised to hear, fundamentally. And I'm going to try and set out the position as clearly and fairly as I'm able. And in that regard, as I indicated when your Lordships rose yesterday evening, in addition to the material already in the bundles, I placed before the Court a small clip of documents from the letters from the representatives of the Reform, to do it in order, I think it's Reform, Liberal and Masorti denominations. Just so your Lordship knows who is who, without reading them out. The first document at page 1 is from Stephen Moss. He's the chairman of the Reform movement. It's a loose clip which should have been placed before each of your Lordships. If any of your Lordships doesn't have it, then we'll supply further copies.
It's marked as additional documents from first intervener, isn't it?
My Lord, yes. Lord, yes. The
basic position seems to be that the other denominations don't like either.
Well, it's
they don't like the Court of Appeal and they don't like the JFS.
That's one way of putting it, my lady, yes.
Well,
and I'm going to try and explain...
I mean no offence thereby.
Of course not. And I'm going to try and explain what in fact underpins their position on each of those points. For reasons which I'll briefly explain in a moment, I was going to explain who's who. The first page is Stephen Moss. He's the chairman of the Reform movement of Great Britain. The second page is an email from Rabbi Danny Rich, who's the chief executive of Liberal Judaism. The third page is an email from Rabbi Jonathan Wittenberg, who, as it says, is the senior rabbi of the Assembly of Masorti Synagogues. And there then follows an article that Rabbi Wittenberg wrote in the Jewish Chronicle, which he wanted placed before the court, and also an article, in fact an interview, with Rabbi Jeffrey Cohen, who's an Orthodox rabbi, which we were asked to place before the court as well, and we were happy to do so. Now, in the limited time I have, can I take it this way? For reasons which I'll briefly explain in a moment, each of those religious bodies is concerned at the involvement of the secular courts in determining the question of how Jewish institutions should define who is a Jew. They all take the position that this is a religious and not a racial issue, which, to use the words of Rabbi Wittenberg, is best addressed not only in the case of Judaism, but perhaps in the case of all faiths, from within the faith community concerned. And they all consider that M was refused a place at JFS because of a religious test, i.e. he was not considered Jewish by the Chief Rabbi. All denominations, therefore, within the community take issue with the conclusion of the Court of Appeal that there was direct discrimination against M on racial grounds. For example, you'll see that the chairman of the Movement for Reform Judaism at page 1 describes the finding that a definition of Jewish status based on descent and conversion necessarily breached the Race Relations Act as, quotes, a damaging and potentially disastrous for the Jewish community. And that explains why the Board of Deputies did not intervene at an earlier stage in this case, because direct discrimination only became an issue, was only found against the school at the level of the Court of Appeal. Each of those denominations, I should add as well, is also concerned, but let me be very clear about this, lest the judgment, although of course it does not itself indicate this, lest the judgment be misconstrued or misused to say that Judaism is racist. And those are matters, therefore, of concern across the Jewish community. But, and this is a very important but, there are significant and important differences between the various denominations. And I therefore make clear to the court that the board's position is not the same as either the school or the United Synagogue. The United Synagogue is one of the denominations represented within the board. The Chief Rabbi is the Chief Rabbi of congregations within the United Synagogue. And therefore, the United Synagogue therefore approves of the fact that JFS looks to the Chief Rabbi when determining whether someone is Jewish. But the non-Orthodox denominations, if I may respectfully and collectively so describe them, take a very different view. The Masorti Reform and Liberal denominations deplore the criteria originally used by JFS to govern its admissions policy prior to the decision of the Court of Appeal. Their position is, as my lady has set out, found not only in the clip of documents, but there are also references in the judgment of Mr. Justice Munby. Just to give your lordships the references, at paragraph 100 of the judgment, the Liberal movement's contention that the previous criteria were politically motivated and unfair is recorded, and the following paragraph quotes Rabbi Dr. Bayfield for the Reform movement, who says the previous criteria were strategically wrong and politically motivated. And those denominations, therefore, want JFS to be more inclusive in its admissions policy and look to other religious bodies, rather than just the Chief Rabbi, to determine whether an applicant is Jewish. The position of the Masorti movement, for example, you'll see, is that they would like anybody recognised as Jewish by any religious denomination to be eligible for admission to the school. And therefore, insofar as the result of the Court of Appeal's decision resolves what they perceive to be an injustice in the original position and allows access to the school to children who could not previously obtain a place there, they understandably like the practical outcome of that decision. Because the practical outcome is that some members of those denominations will be able to obtain a place when they previously could not. And at this stage, perhaps I should re-emphasise the point, because it's a very important point, that when one says, for example, somebody is a Masorti Jew, one has to be very clear about what one means. Does one mean somebody who goes to a Masorti synagogue and subscribes to Masorti theology? and would, however, nonetheless also be regarded as Jewish by the Chief Rabbi? Or is one saying that somebody is a Masorti Jew who will only be regarded as Jewish by the Masorti movement and the movements leftwards, if I can put it with respect in those terms? It's a very important distinction, and with respect, if I may say with great respect, some of the interchanges yesterday, when one talks of a Masorti Jew or a Reform Jew, one has to be very clear as to what actually one means. Because the critical question is whether their Jewish status is recognised only by that movement, and if I may say leftwards, or also rightwards. And that applies mutatis mutandis between Orthodox and Masorti, Masorti and Reform, and so on. But the reason why the board has intervened on behalf of the whole community is because even those denominations remain concerned as to the process by which the decision of the Court of Appeal was reached, as to the reasoning which underpins that decision, and, to varying degrees, as to the inevitable results of the decision. So far as process is concerned, as I've said, they believe the issue should, and perhaps somewhat optimistically could, have been resolved within the Jewish community itself. As to the reasoning of the Court of Appeal, they, like others, are concerned that what is quintessentially a religious dispute about the appropriate criteria for conversion has been characterised as a racial or ethnic issue under the Race Relations Act. And there is a vigorous debate in the community as to the appropriate standards for conversion. If your lordships have a moment after argument has finished, you'll see in Rabbi Dr. Geoffrey Cohen's article towards the end of the clip, he's an Orthodox rabbi who takes the view that the Chief Rabbi is too stringent in applying the test for conversion. But as my Lord Brown observed, the effect of the Court of Appeal's decision is felt more widely because all denominations agree that the primary criterion to determine Jewish status is dissent. That's recorded in the judgment at first instance at paragraph 21. All denominations recognise matrilineal descent, but liberal Judaism, because it seeks to have equality as between men and women, will also accept patrilineal descent. The reliance on matrilineal descent is not new. This came up in argument yesterday, and Lord Panic showed you the Jewish legal sources. That's at Appendix 2, page 550. Since this came up, my lords, I can say that as a matter of history, most scholars would date this, i.e. matrilineal descent, to at least the time of the biblical book of Ezra, which is normally dated to about 400 before the Common Era. The President asked my learned friend Lord Panic whether the fact that it's easier to identify a mother than a father played any part in shaping the rule. And that's certainly an argument which some academics have put forward. More broadly, of course, it raises the very interesting question as to the extent to which theological rules have a sociological underpinning. Perhaps, fortunately, time prevents me from delving too far into that one.
If you go back to these original sources, there you find quite a lot that plainly is racist.
Well, there's a great danger, if I may say, stepping outside Judaism, looking at any ancient document, of applying modern eyes to an ancient document. And indeed, what one may say, that Judaism lives in the dialectic. Indeed, the Talmud is a collection of arguments. And one has, for example, in the Talmud, if I may say, to answer your Lordship's question for a moment, one has a law in the Bible, for example, that if a city is found to be wicked, one annihilates the whole city, people, property, animals, absolutely everything. That is then hedged about in the Talmud with such restrictions that the rabbis say, well, if all these restrictions are valid, one would never have the case when the law would be applied. What's the point of the law? And the answer is given. The point of the law, the reason why the law was given, is to enable us to have this argument about it. So the argument is the important thing. I'm sorry to digress.
Could I ask you, Mr. Wolfson, you may say it isn't going to help us to decide this case in any way, but I keep asking myself that all the submissions we've heard, as if this decision of the Court of Appeal had come from an extraordinary bolt from the blue. But it seems to me that it's been quite apparent since the Mandler decision 25 years ago that this problem would arise sooner or later. The Jewish community is so well informed so intellectual as we see, and so influential. Was there no lobbying when the Equality Act was a bill to deal with this problem?
My Lord, I'm afraid standing on my feet, I can't answer your Lordship's question.
I see that there are no pepper and heart materials, and with the range of talent in front of us, if there were any, no doubt we would have been shown them.
But, my Lord, I'm going to endeavour to finish my submissions by the short adjournment. If over the short adjournment I can find an answer to your Lordship's question, perhaps the President will allow me to address it at 2 o'clock.
Thank you.
And, Lord, to come back to the argument, therefore, based on the result of the Court of Appeal's decision, by denying the legality of a test based on status, the Court of Appeal has produced a result where the only alternative test is one based on practice, or a faith-based test. And that has the unwelcome effect of imposing on the Jewish community, and in particular its schools, what might be termed, with the utmost of respect, a non-Jewish definition of what it is to be Jewish. And that is regarded as unwelcome even by those denominations that prefer the result of the Court of Appeal's decision to that of the status quo ante.
If it's it's practice of what?
Well, my Lord, quite. Practice of what? This is a... I have to turn my mic off. Your Lordships may have seen the practice test that's been set out by, I think, JFS, and no doubt other schools will have other tests. They revolve around things like, do you have a mezuzah, that's the small box with a scroll inside, on your front door? Do you attend synagogue? Are you involved in a Jewish charity? It's very difficult to say from the standpoint of, with respect, all denominations, that those are really the important things. It has
Is the practice of any of these denominations, or practice of, or what?
Well, the JFS test, as I understand it, to take this example, focuses on synagogue attendance, involvement in a Jewish charity, and I think involvement in any denomination, for all denominations. But, for example, central things, that are central to being Jewish, that all denominations would regard as central, for example, keeping kosher, keeping Shabbat, keep the Sabbath day. Different denominations will observe this in different ways, but these are important elements of Judaism for all denominations, but they are not easily susceptible to a tick box test. Very difficult to determine, for example, whether a child's mother has lit candles on Friday night. One can't go snooping around people's houses.
Is it intended to be specific to Orthodox Judaism? This practice test?
No.
Is it possible to do it?
No. It would have to apply to all schools run under any denomination. The problem is that in Judaism there is no central creed. There is no credo. There is no dogma. There is nowhere you can look to find a statement of Jewish belief which is subscribed to by all Jews. It's been tried. The most famous example is Maimonides, the scholar who lived in about the 12th century. Set out 13 principles of faith, 13 principles which he regarded as the basis of Jewish faith. In Montpellier in 1233, his books were burned by a different Jewish community. And your Lordships won't need me to add that for Jewish communities to burn books, something really dramatic has got to go on. So we've tried it for a couple of thousand years, but so far we haven't succeeded. Even if one takes the basic statement of Judaism of "Hear, O Israel, the Lord is our God, the Lord is one," there is a big debate amongst rabbinical sources as to what does that mean. Does that mean, is it saying that you have to have monolatry? In other words, you can only worship God, or is it monotheism, that only God exists? And those two are very different things. They're very important things. And different scholars over the generations have taken different views.
But the position we are in at the moment is that as long as you satisfy the lowest common denominator, as it were, you're okay, is that right?
Yes, and that therefore produces a result where people who would not be recognised as having Jewish status by any denomination can qualify, and people who would be recognised as having Jewish status by all denominations may not qualify. To adopt the metaphor which was used earlier, that really is to try to push a square peg in a round hole. And if I may say, of course, the non-Orthodox denominations like the result of the Court of Appeal's decision. I hope I've made that clear. But even they don't say that it's, so to speak, the right result if one started with a clean sheet of paper. As I hope I've also made clear, what they would favour is the Jewish community internally putting its house in order, if I may say, to put words in their mouths, and having a more inclusive test for admission to JFS.
But for none of the other denominations is practice a requirement, is it?
As I understand the position, that is true for Orthodox Judaism, Masorti Judaism, and Reform Judaism. As I'm instructed, for liberals...
And that's starting at the most right, as you put it earlier, and going left, is it?
It's starting at the most right for the purposes of this hearing, yes. There is always somebody to the right of you, and there is always somebody to the left of you.
But it's all, for this purpose, it's more Orthodox,
Yes.
Masorti, Reform, Liberal, is it?
My instructions are that for liberal Judaism, if there is a single Jewish parent, they will require, in addition to that single Jewish parent, some element of practice. But that is an additional test and not an alternative test. So for all denominations, dissent is or conversion is a necessary criterion.
So if M satisfied Masorti or Reform, but didn't practice, he wouldn't get in now.
Yeah, that's right, yes. If M, for example, didn't attend synagogue and wasn't involved in these various movements, that's right. My Lord, yes, absolutely.
But I mean, Mr. Wilson,
Yes.
I mean, in the end, I mean, we appreciate the differing approaches of the different denominations, and they like the result. I mean, obviously, M likes the result, but as a whole, would all of them ask that the Court of Appeal decision be set aside because, well, for the reasons we all know, I mean, because it rejects a membership test?
Lord, the fairest way to answer that question would be to say that different denominations have a different perspective. Some of them would, so to speak, like your lordships, to produce a result which I fear may be beyond, even with the greatest respect, your lordship's powers, which is to promote a feeling of perhaps mutual respect and understanding in the Jewish community, which sometimes is absent. But, my Lord, some elements in the Jewish community would say, if it's the Court of Appeal or the status quo ante, I'd rather the Court of Appeal. Other elements of the community would say, if it's the Court of Appeal or the status quo ante, I'd rather the status quo ante. I act for the Board of Deputies. I can't give your Lordship a single answer because the community is not speaking with a single voice. On that point. On some points it does, but on that point it doesn't.
As you say, the debate within the Jewish community is about the appropriate standards for conversion. But that's the one thing that isn't addressed, and we couldn't address either.
Well, my Lord, as your Lordship said to my learned friend Mr. Jaffe a minute ago, of course, it depends how you define the question. One way of looking at it is to say this whole debate arises because of different standards of conversion. Another way is to say all Jewish denominations focus on dissent and not practice. Depends where you start from. But, my Lord, yes.
Is it possible to have any feel for statistics? How many come into Judaism by conversion? If one's looking at a Jewish community, how many members of it are going to be converted as opposed to descended Jews?
Lord, it'd be difficult to get such statistics because, first of all, one would have to ask converted by whom, but one would also have to ask converted by whom and when. Yeah. Because, of course, a conversion done 6 generations ago by a non-Orthodox rabbi, the entire line won't be regarded as Orthodox. So if I could find for your Lordship conversion statistics for the various Orthodox, Masorti, etc. bodies in the last year or the last 10 years, but with respect, where would it take your Lordship?
I was just trying to get a broad feel, looking at the present, as it were, generation, not tracing back up the...
But, my Lord, with greater respect, tracing back is what this is all about.
Is there no sort of statute of limitation, a number of generations beyond which they're not going to go back and try and dig for documentary evidence and so on?
Your Lordship raises, if I may say with respect, a very interesting and difficult question. There's a large discussion in the Talmud about a Jewish legal principle called chazakah, which is if one asserts one has a status, one should be presumed to have it. As your Lordships will not be surprised to hear, the instances when that principle applies and when it does not apply are the subject of intense dispute. But, my Lord, that principle is, for example, applied in other areas. The word of somebody that a certain food is kosher, if that person is, for example, a Sabbath-observant Jew, as a matter of Orthodox religious law, that person's word on whether something is kosher would be taken as definitive unless the contrary were proved. But status is a different issue.
But the position of your clients on the actual issues which we could conceivably decide are that they all agree the Court of Appeal was wrong in principle.
Lord,
even though they like the result, is that right?
Yes. Lord, I can only make effective submissions on direct discrimination. On direct discrimination, there is concern across the whole community as to the finding of direct discrimination, and it affects all sections of the community, because I've explained all sections of the community have a Jewish status test based on dissent. Yeah. When it comes to indirect, we speak with different voices. Now, I've been clear, I hope, that I'm making no submissions at all on indirect, either one way or the other. Lord, I'm conscious of the time. If your Lordships will allow me 30 seconds, can I just invite your Lordships to two sections in my printed case. The first is, we've set out between paragraphs 16 and 21 concerns as to the possible implications of the Court of Appeal's judgment, and I respectfully invite your Lordship's attentions to that. And between paragraphs 28 and 30, we've set out concerns that Jewish schools will be treated differently to schools of other faith groups, and we've set out our concerns as to that, and indeed Lord Pannick has addressed that point. Otherwise, and with my apologies for exceeding the time slightly, unless there are any further questions, and subject perhaps coming back to my Lord Walker's point, if I'm able, those are the submissions for the Board of Deputies.
Thank you very much. We'll adjourn until 2 o'clock.
I mean, I'm probably going to